think there's some language that might be a little bit broad, but at bottom, Griffin's case is about a collateral habeas proceeding. And Griffin had brought his case after the fact. He needed a cause of action. Why wouldn't it work in a trial for him to challenge Sheffy's constitutional ability to adjudicate his case?
But what Griffin's case holds is that only Congress can provide the means of enforcing Section 3. And under Your Honor's hypothetical, Congress has not enacted any such statute that would give Mr. Griffin the right to raise those types of arguments at his trial. So he would have to await legislation from Congress.
Okay, let's assume that I disagree with you about the officer argument. So Section 3 covers President Trump. Let's say that Congress enacts a quo warranto provision that would allow a state, or I guess it doesn't really matter for this purpose, even a federal prosecutor, to bring such an action against him, to remove him from office in the quo warranto way. Wouldn't that be in some tension with impeachment? He would be extracted from office outside of the process of impeachment. Couldn't then President Trump simply say, well, the only way to get me out of office is the impeachment process and not this quo warranto action?
So I don't know how that would play out, because the quo warranto actions that were brought, that I'm aware of, under the 1870 Enforcement Act were brought against state officials. And Your Honor's impeachment hypothetical would apply not only to the president, but any federal officer of the United States.
I know.
So I don't know how that played out in the courts and whether anyone ever tried to argue that impeachment was the exclusive remedy for.
Well, I don't think anybody did argue it. I guess what I'm asking is, you said it's Congress's exclusive province.
Yes.
And you also said that it has to apply, after one is holding office, is elected. And I'm asking whether then the implication of your argument is that Congress could not enact such a provision that applied against federal office holders that were covered by Section 3 as opposed to state ones.
I believe they could. And the impeachment clause says that the president, the vice president, and all civil officers of the United States shall be removed from office upon impeachment and conviction. But it doesn't say that's the only way you can remove them. I mean, Congress can defund a position, and effectively, it's not quite the same as formal removal. But the other relevant precedent is Stewart against Laird, when the Jeffersonians repealed the Midnight Judges Act and abolished all of these positions for federal judges. And some people thought that was unconstitutional because they thought the only way you could eliminate federal judges was through impeachment. But Chief Justice Marshall upheld that statute. So that, to me, is a relevant precedent showing that impeachment is not the only way to get rid of a federal official.
Okay, let me just ask one question, and this is just a point of clarification. Does President Trump have any kind of due process right here? I mean, I'm wondering, this kind of goes not to the cause of action point or the preemption point, but more to the question of what procedures he might have been entitled to. You don't make the argument that he was entitled to any, nor did I see the argument that he had any kind of constitutionally protected right to ballot access, so that he was, and constitutionally entitled to an opportunity to be heard. Is that right? He had no due process right?
We made that argument below. We did not make that in our briefs to this court for several reasons. I mean, Your Honor's, I think, suggesting, and this is correct, that the proceedings below, to put it charitably, were highly irregular.
Well, I wasn't suggesting that. I was just asking.
The question seems to suggest that there might be due process issues, but we didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling. We didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling specific to this particular proceeding in the state of Colorado and would leave the door open for Colorado to continue on remand to exclude him from the ballot.
Okay, thank you.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected, I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, you know, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true, I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck, the first mover state here, Colorado, we're stuck with that record. And, you know, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, you know, the hearsay rules are, you know, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, you know, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
Thank you.
Justice Barrett?
So the general rule is that absent rare circumstances, state courts and federal courts share authority. State courts have authority to enforce the Constitution, but there are certain limits to that, certain situations in which the Constitution itself preempts the state's ability to resolve constitutional questions. And, you know, Tarbell's case is one, and you said earlier that once a president is elected, you accepted that a state couldn't do anything about that. Like Colorado couldn't enact its own, say, quo warranto provision and then use it to get the Secretary of State or the President or anyone else out of office. And I assume that's because of this principle of structural preemption. Am I right?
Yes, Your Honor.
Okay. So I just want to clarify what that means for your argument. That means that your eggs are really in the basket of the Electors Clause, really in the Article 1 basket, because you're saying that even though all of the questions that people have been asking have suggested that there's a problem with giving a single state the authority to render a decision that would have an effect on the national election, but you're saying that those structural concerns, which might otherwise lead to the kind of result that you would accept after someone is in office, are overcome by the Electors Clause.
Absolutely. States run presidential elections. That's very clear from Article 2. Once states have selected the electors and the electors have voted, states have no more power over the candidate who has been then nominated for president. But until then, the states do have the power to adjudicate those issues.
Thank you.
Thank you. You're welcome.
Justice Kavanaugh?
The concerns of some question have been the states having such power over a national office, other questions about the different states having different standards of proof, and they seem underscored by this case, at least the dissenting opinion below. Justice Sotomayor said, I've been involved, quote, I've been involved in the justice system for 33 years now, and what took place here doesn't resemble anything I've seen in a courtroom, end quote, and then added, quote, what transpired in this litigation fell woefully short of what due process demands, end quote. Now, I don't know whether I agree or not. I'm not going to take a position on that, but the fact that someone's complaining not about the bottom line conclusion, but about the very processes that were used in the state would seem to, and that would be permitted, seems to underscore the concerns that have been raised about state power. Just wanted to give you a chance to address that, because that was powerful language. Again, not disagreeing about the conclusion, but about the very fairness of the process.
Yes, Your Honor, but that language was, with respect to Justice Sotomayor, just not correct. President Trump had a 5-day trial in this case. He had the opportunity to call any witnesses that he wanted. He had the opportunity to cross-examine our witnesses. He had the opportunity to testify if he wanted to testify. And of course the process was expedited because ballot access decisions are always on a fast schedule. But in this whole case, from the trial court all the way up to this court, President Trump has never identified a single process other than expert depositions that he wanted to have that he didn't get. He had the opportunity for fact witness depositions. He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, it says shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted about 6 years before Section 3. It wasn't meant as implementing legislation related to Section 3. And I would emphasize that by the time that Section 3 was ratified, most Confederates had already received criminal pardons.
I guess the question is a little bit different, which is if the concern you have, which I understand, is that insurrectionists should not be able to hold federal office, there is a tool to ensure that that does not happen, namely federal prosecution of insurrectionists. And if convicted, Congress made clear you are automatically barred from holding a federal office. That tool exists, you agree, and could be used, but has not, could be used against someone who committed insurrection. You agree with that?
That's absolutely right, Your Honor. But I would just make the point that the framers of Section 3 clearly understood that criminal prosecutions weren't sufficient because oftentimes insurrectionists go unpunished, as was the case in the Civil War, and that the least we can do is impose a civil disqualification penalty so that even if we don't have the stomach to throw someone in jail...
They had the quo warranto provision that was in effect then from 1870 until 1948, but then obviously that dropped out and hasn't been seen as necessary since then. Last question. In trying to figure out what Section 3 means, and to the extent it's elusive language or vague language, what about the idea that we should think about democracy, think about the right of the people to elect candidates of their choice, of letting the people decide, because your position has the effect of disenfranchising voters to a significant degree. And should that be something, does that come in when we think about should we read Section 3 this way or read it that way? What about the background principle, if you agree, of democracy?
I'd like to make 3 points on that, Justice Kavanaugh. The first is that constitutional safeguards are for the purpose of safeguarding our democracy, not just for the next election cycle, but for generations to come. And second, Section 3 is designed to protect our democracy in that very way. The framers of Section 3 knew from painful experience that those who had violently broken their oaths to the Constitution couldn't be trusted to hold power again because they could dismantle our constitutional democracy from within. And so they created a democratic safety valve. President Trump can go ask Congress to give him amnesty by a 2/3 vote. But unless he does that, our Constitution protects us from insurrectionists. And third, this case illustrates the danger of refusing to apply Section 3 as written, because the reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't require that he be given another chance.
Justice Jackson?
Back to whether the presidency is one of the barred offices, I guess I'm a little surprised at your response to Justice Kagan, because I thought that the history of the 14th Amendment actually provides the reason for why the presidency may not be included. And by that I mean, I didn't see any evidence that the presidency was top of mind for the framers when they were drafting Section 3, because they were actually dealing with a different issue. The pressing concern, at least as I see the historical record, was actually what was going on at lower levels of the government. The possible infiltration and embedding of insurrectionists into the state government apparatus, and the real risk that former Confederates might return to power in the South via state-level elections, either in local offices or as representatives of the states in Congress. And that's a very different lens. If your concern is trying to make sure that these people don't come back through the state apparatus and control the government in that direction, seems to me very different than the worry that an insurrectionist will seize control of the entire national government through the presidency. And so I just am surprised that you would, given the text of the provision and the historical context that seems to demonstrate that their concern or their focus was not about the presidency, I just don't understand why you're giving that argument up.
There is some evidence to suggest that, Justice.
Is there any evidence to suggest that the presidency was what they were focused on?
There is some evidence of that. There were people saying we don't want Jefferson Davis to be elected president, and there was also one of the drafts of Section 3 specifically mentioned the presidency and the vice presidency.
But it wasn't the final. It wasn't the final.
It wasn't the final.
So
it wasn't. Yes,
right.
I'm sorry. It wasn't the final enactment, but it does show that there was some concern by some people about Confederate insurrectionists ascending to the presidency. And we didn't want to make a law office history type argument where we just look at the historical evidence and pick the evidence that we like and interpret it tendentiously, because the other side can get back with us and throw this countervailing evidence back in our face. So we wanted to focus more on the text of the Constitution, because this was ultimately a compromise provision that was enacted in Section 3.
All right, let me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this court's decision.
So your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement?
That's correct.
All right. Final question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6 qualified as an insurrection, as defined by Section 3, and I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an insurrection? What is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons, but for an insurrection there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so the point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson, right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection as that term is used in Section 3.
Thank you.
Thanks.
Thank you, counsel.
The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons. The first reason is that President Trump is not covered by Section 3 because the President is not an officer of the United States, as that term is used throughout the Constitution. Officer of the United States refers only to appointed officials, and it does not encompass elected individuals, such as the President or members of Congress. This is clear from the Commissions Clause, the Impeachment Clause, and the Appointments Clause, each of which uses officers of the United States to refer only to appointed and not elected officials. The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3, because Congress can lift that disability after the candidate is elected, but before he takes office. A state cannot exclude any candidate for federal office from the ballot on account of Section 3, and any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office. The Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally imposed qualification and is thereby violating the holding of term limits. And in this situation, a ruling from this court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans. I welcome the court's questions.
There was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect, because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. It'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason...
Well, no, hold on. I mean, you might think they're frivolous, but the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we will be deciding, whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor, just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point that it's been...
Mr. Mitchell, would you, you didn't spend much time on your argument with respect to whether or not Section 3 is self-executing. So would you address that? And in doing that, your argument is that it's not self-executing, but then in that case, what would the role of the state be? Or is it entirely up to Congress to implement the disqualification in Section 3?
It is entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce Section 3 of the 14th Amendment unless and until Congress enacts implementing legislation allowing it to do so. So under Griffin's case, which we believe is correctly decided, the Anderson litigants disagree with us on that point, but if this court were to adhere to the holding of Griffin's case, there would not be any role for the states in enforcing Section 3 unless Congress were to enact a statute that gives them that authority.
Counsel, what if somebody came into a state Secretary of State's office and said, I took the oath specified in Section 3, I participated in an insurrection, and I want to be on the ballot. Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that consistent with term limits, because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office, and then see whether Congress lifts that disability after the election. This happened frequently in the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each house would determine for itself whether to seat that elected insurrectionist, because each house is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical, the Secretary of State would be demanding, essentially, that the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
Well, even though it's pretty unlikely, or at least would be difficult for an individual who says, you know, I am an insurrectionist and I had taken the oath, that would require 2/3 of votes in Congress, right?
Correct.
Well, this is a pretty unlikely scenario.
It may be unlikely, but no Secretary of State is permitted to predict the likelihood of a waiver, because in doing so, they're adding a new qualification to the ability to run for Congress. And the proper analogy, Mr. Chief Justice, is to state residency laws, because the Constitution says that a member of Congress must inhabit the state that he represents when elected. And the lower courts have all held, in reliance on term limits, that a state election official cannot move that deadline any earlier by requiring the candidate for Congress to inhabit the state.
So even if somebody
election
comes in and says, I'm a resident of the Secretary of State's office in Illinois, and says, I'm a resident of Indiana, I have been all my life, I want to run for office in Illinois, the Secretary of State can't say, no, you can't?
Well, the question would be, is that person going to inhabit the state when the election is held? So if the candidate makes clear, perhaps through a sworn declaration or through his own statements, that he has no intention of relocating to that state before Election Day, then the Secretary of State would be enforcing an extant constitutional qualification rather than enforcing a new state-imposed qualification. And that's the key under term limits. Is the state in any way altering the criteria for a federal office, either for Congress or for the presidency? And in this situation, the Colorado Supreme Court is going slightly beyond what Section 3 requires, because Section 3, on its face, bans an insurrectionist only from holding office.
Do you have contemporaneous examples, and by contemporaneous I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting federal officer. So
what was the purpose of Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War, and there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making, and what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s.
I go to that point.
After the...
Justice Alito?
I don't know how much we can infer from the fact that we haven't seen anything like this before, and therefore conclude that we're not going to see something in the future. From the time of the impeachment of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order, over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this court affirms, this court can write an opinion that emphasizes how extraordinary insurrection against the Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th, a coordinated attempt to disrupt a function mandated by the 12th Amendment and essential to constitutional transfer.
Well, let me ask you a question about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And suppose that candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist, so the legislature then passes a law ordering its electors to vote for the other candidate. You think the state has that power?
I think there may be principles that come into play in terms of after the people have voted, that the state can't change the rules midstream. I'm not sure because I'm not aware of this court addressing it. And certainly,
well, let's change it so that it's not after the election. It's 3 days before the election based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision in Chafala, where this court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Justice Alito?
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof. Then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately, what we have here is an insurrection that was incited in plain sight.
But you're really not answering my question. It's not helpful if you don't do that. Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
First, this court would set the legal standard, and then it would decide which view of the record was correct, I think, under that. Which
view of what record? Which record?
If this court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
Well, you had an expert, let's just take that example, an expert testify about the meaning of what President Trump said. But do you think it's possible that a different state court would apply Daubert differently and say that this person should not be allowed to express an expert opinion on that question? You think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Sonia he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built around videotaped statements of President Trump himself encouraging, inciting, and praising political violence.
Well, I'm not taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states, that different states will disqualify different candidates, but I'm not getting a whole lot of help from you about how this would not be an unmanageable situation.
If this court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law, or at the very least this court could address that when those issues come up, but it seems unlikely.
You keep saying term limits. There are other presidential qualifications in the Constitution: age,
Yes.
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term. We have a history of states disqualifying, not all, but some, of disqualifying candidates who won't be of age if elected. We have a history of at least one state disqualifying someone who wasn't a U.S. citizen.
Right.
Are your arguments limited to Section 3?
Not quite. The question, Justice Sotomayor, is whether the state is violating term limits by adding to or altering the extant qualifications for the presidency in the Constitution. Now,
so you want us to say, I'm wondering why the term limits qualification is important to you.
Because
are you setting up so that if some president runs for a third term, that a state can't disqualify him from the ballot?
Of course a state can disqualify him from the ballot, because that is a qualification that is categorical. It's not defeasible by Congress. So a state is enforcing the Constitution when it says you can't appear on our ballot if you've already served 2 terms as president. The same
if they're underage when elected, and the same if they're not a U.S. citizen.
The same if they're not, the same if they're not a U.S. citizen for sure. The age is a little more nuanced, because you can imagine a scenario where the person is 34 years old at the time of the election, but he turns 35 before inauguration.
Well, then that would probably come up to us at some point. The state would make a decision and say he's ineligible, and we would have to decide that question then. But my point is, so adding qualifications to what term limit is your argument based on?
I'm just
confused.
Okay. With respect to maybe I'll start with the age example. If a state like Colorado says you can't appear on our presidential ballot unless you are 35 years old on the day of the election, that would be a violation of term limits, because there could be a 34-year-old on the day of the election who turns 35 before inauguration day. What Colorado has done here, what their Supreme Court has done, is similar, because under Section 3, President Trump needs to qualify during the time that he would hold office, And the Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that we, the state Supreme Court.
Now I understand.
Now, just a point of clarification so we're all on the same page. When you say term limits, you mean our decision in the term limits case.
Yes, I'm sorry.
The constitutional provision governing term limits.
Yes, U.S. term limits against Thornton. Maybe I should call it Thornton instead of term limits.
That would be
sorry.
Justice Sotomayor?
Pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal that it's not Section 3 that's at issue, but Thornton and others as to whether Section 3 can be enforced by states against the president?
That would extend to every presidential candidate, not
exactly,
just our client.
not just
That's
to
correct.
yours.
Yes.
Okay, thank you. Counsel, can I stop you a moment and back up a minute? You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional provision.
Correct.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has provided that cause of action. You want to go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist.
That's correct. So
under Section 3.
That's right.
So history proves a lot to me and to my colleagues generally. But there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. You want to, maybe 3. You want us to say that self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. And so this is a complete preemption in a way that's very rare, isn't it?
Well, that's the only thing I would disagree.
It's rare under the 14th Amendment.
Oh, of course it's rare. This is a one-off situation. And, Your Honor, the only thing
it is one-off. I don't disagree with you. But it's not with respect to how we've defined self-executing.
We're not asking this court to redefine the concept of non-self-execution. We were careful in our brief not to rely on that phrase. And Griffin's
right,
case
you are because it's not.
That's right. And
okay,
Griffin's
so
case...
now the question is a very different one in my mind. I understand what you're relying on, Griffin. Let's just be very clear.
Right.
Griffin was not a precedential Supreme Court decision.
That's correct.
All right? It was a circuit court decision by a justice who, when he becomes a justice, writes in the Davies case, he assumed that Jefferson Davis would be ineligible to hold any office, particularly the presidency, and treated, and this is his words, Section 3 as executing itself, needing no legislation on the part of Congress to give it effect. So you're relying on a non-presidential case by a justice who later takes back what he said.
But the key point with Griffin's case and why it's an important precedent, despite everything Your Honor said, it is not a precedent of this court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for Section 3.
And it did away with it later.
It did away with it later, but
that has nothing to say with respect to what Section 3 means. Can we get to the issue, which is, I think, one that I go back to that I started with, and very briefly, what sense does it say that states can't enforce Section 3 against their own officials? I think logically those are two separate issues in my mind. Can states enforce the Insurrection Clause against their own office holders, or can they enforce it against federal officials, or can they enforce it against the president? Those are all three different questions in my mind.
And the answer to all three of those questions turns on whether this court agrees with the holding of Griffin's case. If Griffin's case is the proper enunciation of the law, then a state cannot do any of the things Your Honor suggested unless Congress gives it authority to do so.
So a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as presidential?
Because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870 and established...
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary, to say that the only people who have engaged in insurrection who are not disqualified from office are presidents who have not held high office before. Why would that rule exist?
I don't think there is a good rationale given that this was compromised legislation. And sometimes this happens with statutory compromises and even constitutional compromises. There's an agreed upon set of words that can pass both houses of Congress. But different legislators may have had goals and motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall for motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall through the cracks in a sense. But if officer of the United States means appointed officials, there's just no way he can be covered under Section 3. The court would have to reject our officer argument to get to that point.
And is there any better reason if you go to the office argument that Justice Jackson was suggesting, is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's an even tougher argument for us to make as a policy matter, because one would think of all offices, the presidency would be the one you'd want to keep out the Confederate insurrectionists. That's the commander-in-chief of the Army. So, again, that's why we're leaning more on the officer of argument than the office under. We're not conceding office under, but we definitely have the stronger textual case and structural case on officer of the United States.
Thank you.
Thanks for understanding.
Now, why don't we move on to the officer point?
Certainly.
And Justice Jackson, I think you...
Yeah, so I had a question about it because you're making a textualist argument. And as I look at Section 3, I see two parts of the first sentence of Section 3. The first is a list of offices that a disqualified person is barred from holding. And the second are specific circumstances that give rise to disqualification. So first, am I right about seeing that there are two different things happening in the first sentence of section? Okay.
For sure.
So are you arguing both in this case or just one? Are you arguing both that the office of the presidency should not be considered one of the barred offices and that a person who previously took the presidential oath is not subject to disqualification?
We are arguing both, Your Honor.
I don't see that in your brief. I see a lot of focus on the second, but not on the first.
There is definitely more focus on the second, and we acknowledge that we have a somewhat heavier lift on the first point.
Why? It seems to me that you have a list and president is not on it.
That's certainly an argument in our favor, but there are also with respect to officer of the United States, that's used repeatedly in the Constitution, in the Commissions Clause, in the Appointments Clause, and also in the Impeachment Clause. And every time it appears, it's used in a way that clearly excludes the
No, I
president.
understand, but that's
So
the
we don't-
second argument. So the
That is.
first
And the-
argument
Mhm.
is we have a list of offices
Yes.
that a person is barred from holding, right?
Yes.
Under your theory, or under the language of, and we see it begins with senator, representative, elector of the
Elect-
president and vice president, and all other civil or military officers.
Well, offices under the United States.
Offices under the United States.
How
But
it's
the
phrased.
word president or vice president does not appear specifically
That's
in
right.
that list. So I guess I'm trying to understand, are you giving up that argument, and
No.
if so, why?
No, we're not giving it up at all. You're right. The president and the vice president are not specifically listed. But the Anderson litigants claim that they are encompassed within the meaning of the phrase office under the United States.
And do you
that-
agree that the framers would have put such a high and significant and important office, sort of smuggled it in through that catch-all phrase?
We don't agree at all. That's why we're still making the argument that the presidency is excluded from the covered offices that are listed at the beginning of Section 3.
I'm sorry, your brief says you didn't take a position on that point.
I'm sorry.
And your brief said, I don't have the site, I apologize. You don't affirmatively argue that point, I think is what your brief said.
In the blue brief?
Yes.
Well, we certainly argued it in the reply brief, and I'll have to look at how we phrased it. But we did point out in our opening brief that there are potential issues if this court were to rule on office under, because that phrase appears in other parts of the Constitution, including the Emoluments Clause, the Impeachment Disqualification Clause.
Would we
and the
necessarily
Compatibility
have to
Clause.
say, I mean, I thought the point was that Section 3 was unique, that there was something happening with Section 3 that could explain why certain offices were left off or whatnot.
Perhaps, but there are also implications from other parts of the Constitution which really help us on the officer of the United States argument in that second part of Section 3, but somewhat cut against us when it comes to office under the United States. And the Anderson litigants point this out in footnote 9 in the red brief, where they say if this court were to say the presidency is an excluded office under the United States, that could imply, for example, the president is not covered by the emolument.
Justice Jackson?
So when I asked you earlier about the uniformity concern and the troubling potential disuniformity of having different states enforce Section 3 with respect to presidential elections, you seem to point to history in a certain way. You said, I think, that the framers actually envisioned states enforcing Section 3, at least in some circumstances where there were insurgents and Confederates. And I guess in my view of the history, I'm wondering really whether presidential elections were such a circumstance, that the framers actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections as opposed to focusing on the presidency?
2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and anything else. Yeah.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
This came up in the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included President and Vice President in the language? And Senator Moore responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Well, Reverdy Johnson came back and agreed with that reading. Any office is clear. The Constitution says about 20 times.
No, I'm not going to go. So let me just say, so your point is that that there's no ambiguity. With having a list and not having president in it, with having a history that suggests that they were really focused on local concerns in the South, with this conversation where the legislators actually discussed what looked like an ambiguity. You're saying there is no ambiguity in Section 3?
Let me take the point specifically about electors and senators, if I might, because I think that's important. Presidential electors were not covered because they don't hold an office. They vote. And this
I'm talking about the barred office part of this.
Exactly. So the barred offices, if you want to include everybody, first you have to specify presidential electors because they're not offices, so they wouldn't fall under any office. Second of all, senators and representatives don't hold office either. The Constitution tells us that under the Incompatibility Clause and refers to them as holding seats, not offices. And so you want to make sure that there's no doubt that senators and representatives are covered. Given that the Constitution suggests otherwise, you have to include them. The Constitution says the presidency holds an office, as do members of this court. And so other high offices, the president, vice president, members of this court.
All right, let me ask you, I appreciate that argument. If we think that the states can't enforce this provision for whatever reason in this context, in the presidential context, what happens next in this case? I mean, is it done?
If this court concludes that Colorado did not have the authority to exclude President Trump from the presidential ballot on procedural grounds, I think this case would be done, but I think it could come back with a vengeance because ultimately members of Congress may have to make the determination after a presidential election if President Trump wins about whether or not he's disqualified from office and whether to count votes cast for him under the Electoral Count Reform Act. So President Trump himself urges this court in the first few pages of his brief to resolve the issues on the merits, and we think that the court should do so as well.
And there's no federal litigation, you would say?
Well, that's correct, because there is no federal procedure for deciding these issues, short of a criminal prosecution.
Thank you.
Murray, just to circle back to, I'm sorry to interrupt, but I wanted to, before we left it, I wanted to circle back to where Justice Kagan was. Do you agree that the state's powers here over its ballot for a federal officer election have to come from some constitutional authority?
Members of this court have disagreed about that.
I'm asking you.
The majority of this court has said that those powers come from Article 2, but we think that the result is the same whether the court locates it in Article 2 or in a reserved power under the 10th Amendment.
But you accept that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here, we're not talking about the qualifications clause, right? Nobody's talking about whether he's 35 years old or natural born, whatever, right? Not an issue, okay? We're talking about something under the 14th Amendment and Section 3, so that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their elections.
Federal election, but this is for a federal office that has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits.
Yeah, I would think so, right? So it has to come back to Section 3. And if that's true, how does that work
given that Section 3 speaks about holding office, not who may run for office. It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications clause, which is all about who can run and then serve, yeah.
I don't know that it is different. Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it. So thoughts on that?
Well, the fact that there's an extraordinary provision for removing the disability does not negate the fact that the disability exists today, and it's existed since January 6, 2021, when President Trump engaged in insurrection against the Constitution.
So were his actions after that date, before he left office, ultra vires? Is that where your theory leads?
Well, that would raise the separate question of whether one can collaterally attack the actions of a de facto officer. And that may be the one place in Griffin's case at the very end where we would agree, which is when Justice Chase said, I've talked to my Supreme Court colleagues and we unanimously agree that you can't collaterally attack all official actions of an officer who's in fact holding the position.
Right, but just circle back to where we started, right? That this is Section 3, your authority has to come from there, and it's about holding office, and it's a particular kind of disability that can be removed by Congress, and it's the only one like that, right? They can't remove age or citizenship. How should that inform our thoughts about a state's efforts to regulate the ballot for a federal office?
The colloquy that my friend had with Justice Alito earlier, I think, is illustrative here. The fact that Congress has an extraordinary removal power does not negate that the disability exists today and exists indefinitely into the future, much like the fact that the president can pardon somebody for a criminal conviction doesn't make that conviction somehow contingent. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office, which shows that the disability exists now. And the fact that Congress has a power to remove the disability doesn't negate the present qualification, nor does it implicitly bestow on President Trump a constitutional right to run for offices that he cannot hold in violation of state law and state procedure under Article 2.
In fact,